welcome Paul to come up and be happy to answer your questions. Thank you for having me.
Well, first of all, let me say I'm here with my compadres, the plus 60 lawyers. So I want you to know that I really feel at home, and thank you for inviting me to come home with my compadres. Secondly, Rob Hendrickson, who is just a gentleman of a person, I've known since law school. And when I was in law school, Rob was a judge in the moot court presentation that my partner and I made against two other lawyers. And it's interesting to note that, you know, as is typical of the times, one of those lawyers has retired. One of those lawyers is a federal judge. The third lawyer is me, I'm here. And the fourth lawyer is serving a 99-year sentence in Texas. So kind of typical. It's always a pleasure to be here with my good friend Paul Tiburzi, who is an outstanding lawyer, and as you know, is the person who really runs DLA Piper here in Baltimore. This issue, for all of us, is not a new issue. But what makes it a new issue in today's world is that the Court of Appeals granted certiorari in a case before the Court of Special Appeals decided it. And that case is called Coleman, C-O-L-E-M-A-N, versus Soccer Association of Columbia. And in that case, when the case was tried, there was a preservation of the issue because there was a submission of a comparative negligence instruction, which was rejected. And Paul and I can probably debate the facts of the case. Paul says, well, this was a guy who was high on marijuana and he got hit in the face by a soccer pole. Well, the other side is this was a 20-year-old kid who was a volunteer helping out coaching a team, and he was retrieving a ball from a soccer goal, and he, as is typical, as what happens a lot of times, grabbed onto the soccer post. It was improperly anchored. It fell. It hit him in the face, crushed his face. He has a titanium plate in his face. So, as is typical with plaintiff and defense lawyers, there are different ways of looking at the facts of the case. But for some reason, the Court of Appeals granted cert before the decision of the Court of Special Appeals. And many of us believe that the court will address straight on the issue of whether or not to abrogate contributory negligence. The court has been faced on a number of occasions with the issue. The last time was probably in the 80s, and they said, we're going to defer to the legislature. However, that may not be the case today. I have put before you in summary form a little bit about the history of contrib in Maryland. It originally appeared in an 1809 English case, and it was first cited in an 1847 Maryland case that goes back to the Gill Reporter. And I'm sure all of you are familiar with the Gill Reporter.
The names are in it.
And that's where it started, and that's where it has remained. And as Paul appropriately points out, this is a judicially created doctrine. So, you say to yourself, if this is a judicially created doctrine, can the Court of Appeals change it without deferring to the legislature, which it has said it would do? And as Paul so rightly points out, in the past, they did defer to the legislature. But the court Court of Appeals of Maryland has on more than just a few occasions decided to change the common law of Maryland. And I want to quote something to you that talks about the common law. And tell me whether or not this quote rings true. The common law is not static. Its life and heart is its dynamism, its ability to keep pace with the world while constantly searching for just and fair solutions to pressing societal problems. The common law is subject to judicial modification in light of modern circumstances or increased knowledge. And I don't think anybody would really disagree with that basic concept. And for that reason, and I know Maryland has done this on many occasions where it has changed the common law, it is looked to what other jurisdictions have done. What's the majority rule? What's the minority rule? And is there just reason for us to go with the majority or with the minority? And the Court of Appeals has done both. So what I've set forth in the materials that you have is a little summary of what has happened around the United States. There are 46 states that have comparative negligence of some type. 46. Can 46 out of 50 be wrong? Somebody once said to me, if you go through life and you're right 90% of the time, you're doing pretty darn well. Well, that would be 45. There are 46 states that have adopted some type of comparative fault. There are 12 states, and I've listed them, that have judicially abrogated contributory negligence by their Supreme Court or by their highest court. 12. And to the point that Paul raises about some of the issues which we can certainly talk about is it going to be pure? Is it going to affect joint and several liability? What is the effective date? What type of contrib is going to be? Are we going to retain assumption of risk? In a number of states which have judicially abrogated contributory negligence, the legislature has then come in and has affirmed the abrogation and then has modified it in some way. There have been no states, 0, that have abrogated contrib, judicially or by the legislature, and then have gone back and said, we made a mistake, let's go back to contrib. We've heard for many, many, many years that this is going to open up the floodgates. This is going to bankrupt the city, the state, small businesses. This law will be a disaster. This law is bad for business. And my answer to that is, can 46 states be wrong? Because 46 states have done that. And Maryland is not in the lower, in the top 1 business, pro-business states in the country. It's not. So those arguments, I think, ring hollow because of the nature of the concept of contributory negligence versus comparative negligence. And I just want to give you an example of what I see sometimes when I go to court. And we have some very fine defense lawyers sitting there in the back who try a lot of cases. Neil Brown and Tony Bresci there, among others. Glenn Bushell, who try cases. And here's what I see when I go to court. And let's take an automobile case. We take out this blank piece of paper, and it's clean, and it's full, and it's complete. And then we have the good defense lawyers get up there and they say, members of the jury, I have to tell you that my client was at fault in this accident. And it was an accident, it wasn't intentional. But my client was not the only one that was at fault. And I'm going to admit to you that my client was the major party at fault. But Mr. Smith, who is the plaintiff in this case, really stopped his car a little bit short. And I'm going to say that he was, my client, 95% at fault. But the plaintiff, Mr. Smith, was 5% at fault. End of case. Because the court is going to instruct the jury that if you find that the plaintiff caused or contributed to the happening of the incident, then the plaintiff is not entitled to recover. And what has happened, and Paul says there really aren't any horror stories and they haven't been out in the sun and they haven't been down in the legislature. Well, I've seen the horror stories where somebody is alleged to have been grossly negligent, defendant, and the plaintiff may have contributed to some small extent to their injury, and it could be a 95-5, a 90-10, and that person gets nothing. Zero, zip, nada. And one of the reasons that I think has been advanced and why contributory negligence has fallen by the wayside is because it relieves a very culpable person of responsibility. And our society, for better or for worse, has relied upon fault, responsibility, as a basic tenet of our legal system. If somebody is negligent, then they are responsible for all of the natural and probable consequences of their negligence. If someone is contributorily negligent to an extent, they should be responsible to whatever extent they may have contributed to the incident. So in what's called a pure contributory negligence context, that's 100%. If somebody is 90% at fault and the plaintiff is 10% at fault, they could recover 10% of their damages. If someone is 60% at fault and the plaintiff is 40% at fault, they can recover 40%. And then there are cases where the plaintiff may be 70% at fault and the defendant 30% at fault, and they can only recover 30% of their damages. I tried a case many years ago in federal court which dealt with the admiralty and maritime law, which for over 225 years has comparative fault as its doctrine. And it's a pure system. And this was a Donnybrook. There was a guy who was conducting a gambling operation on board ship. He was running numbers on ship. He welched on a bet, and a guy hit him over the top of the head with a big reefer plug adapter, smashed open his skull. He must have had 50 stitches, and he was knocked out of work for months. And we alleged that the vessel was unseaworthy because it had hired somebody who was so evil and had such a bad disposition and such a bad character that it rendered the whole vessel unseaworthy. And the jury agreed. But they found the plaintiff 90% at fault, and he could only recover 10% of his damages. Now, what Maryland would do if it should decide to go to a comparative fault system is it is clearly unknown what they would do. Would they adopt 100% pure, where they go to, you can't be more than 50% negligent to recover. But it kind of answers the question that Paul raises about things like the effective date of the decision, if they should abrogate it. Well, recently the Court of Appeals decided a case called Tracy versus Selesky involving the pit bulls, and held that, in essence, eventually, that if it was a purebred pit bull, there could be strict liability for an injury caused by that pit bull. And in the opinion, as it has done on many occasions, the Court of Appeals says this opinion and this decision applies only to causes of action that arise after the date of the decision. And that's typical about changes in the law. And if you look at the cases that have been cited in the materials that deal with changes in the common law of Maryland, those are cases where the Court of Appeals has decided, basically, that the time had come to make the change. And the circumstances were such that the time had come to make the change. So, as is the case, whenever the court may render a decision, the legislature has the authority to change it or to modify it, unless it's a constitutional issue. And it's just like, an analogy I could give you is immunity. We have in Maryland circumstances where individuals enjoy immunity. And Paul knows this better than I. Every year, there are bills introduced about people who want immunity to get the shield that they're not responsible. I even think there's a bill introduced that Neil Brown wanted immunity. But everybody wants immunity. And we see it all the time. What would likely happen if the Court of Appeals decides to abrogate contributory negligence and go with a comparative standard is that there will be bills to modify, bills to change. Is it going to be pure? What are we going to do with joint and several? What are we going to do with assumption of risk? What are we going to do with the effective date if the Court of Appeals doesn't deal with that issue, which I think the Court of Appeals will. And those things can sift themselves out, as they always do when the court may come up with a decision that the legislature may not necessarily agree with. So there are ways to deal with and to handle the situation. The other factors that I've listed in terms of reasons why, besides accountability, is really fairness. It is really a doctrine of fairness. Fairness in the sense that if somebody is at fault under the law, they should pay fair and reasonable damages. But if somebody contributes to their own injury, they too bear responsibility for their injury, and they should be held accountable as well. Now, I mentioned the Admiralty and Maritime Law, which has adopted comparative for over 225 years. Those cases are tried all over. They're tried not only in federal court, they're tried in state court. Courts know how to deal with them. They're very simple. The jury doesn't make the calculations. The jury is merely asked, do you find that the plaintiff, the defendant, was negligent and that the negligence was a proximate cause of the injury to the plaintiff? Yes, no. And then second question, do you find that the plaintiff caused or contributed to their own injury? And then question number 3, if you answered question number 2 yes, in what percent do you find that the defendant caused or contributed to the plaintiff's injury, or that the plaintiff caused or contributed to his own injury? And then the court makes the calculations, and the jury goes on to determine damages. That's the way it's been done. It's been done in federal court forever. It's been done in state court in cases where the maritime law applies. And it's even been done in cases where Maryland, which is a lex loci delicti state, that means it applies basically the law of the place where the incident may have occurred, which may be a comparative state. They'll apply the foreign law, and then the foreign law would require that they use comparative negligence, since Maryland is one of the 4 outliers. But I would think that if it turns out, likely, that, and I agree with Paul, that predictions are impossible, and reading the tea leaves are impossible, maybe Judge Radowski can give us some insight as to that. It's just impossible to know what the court will do, when the court will do it, and if they do it, how they're going to shape it. But it is very clear to me that the court is going to rule on this head on. And it's going to be very, very interesting to see what they do, when they do it, and how they do it. Thanks a lot for letting me be here with you today.